Eric, did we ever test your camera? I don't think we did.
Oh, let me check. I'm sorry.
Okay. Yay. Awesome.
Yay. Okay.
Good morning, Susanna. Do you want to test your mic for me real quick? We can see you.
Yes. Good morning, Angelica.
Good morning. Great. All right. We have all staff and all. Oh, looks like Miss Stewart is about to log on. Great. Mr. Brooks, I was just given word that Miss Stewart is about to log on. So if you want to, we still have 2 minutes, but just in case she's not on by 10, if you want to give her a little time to get logged in. All right, Mr. Brooks, I do show 10, but I don't see Miss Stewart has logged on yet. If you want to proceed, then we can just acknowledge her when she does. Or if you want to maybe give her another minute or so. She let our staff know that she was attempting to log on. So
Do we need her to have a quorum?
no, now that Ms. Trost is here, we can proceed. So we have our quorum right now, if you would like to get started.
Excellent. Well, thank you. Well, then we'll go ahead and call the meeting to order. It is now 10 o'clock. We do appreciate everyone being here. Thank you so much. Please mute your microphones if you're not in the process of speaking. Please, if you would, please announce your name so that all that can be appropriately recorded. We'll move on to item number B, which is roll call and certification of quorum. Ms. Lopez Sparks, would you mind doing the roll call?
Yes, sir. Christopher Beisel,
Here.
Richard Davila,
Here. Hi. Here.
Ms. Stewart.
Here.
This is for, okay. And this is for the approval of the minutes, by the way. And presiding officer Vance Brooks.
I, with the modification,
Yes.
approve or support the approval of the minutes.
Great. All right, motion passes, sir.
Thank you. Thank you all very much.
Mhm.
So moving on to the public comment section, item number D. There were no requests that would fall into the category of asking to make public comment during this meeting. All right, moving on to item number E, the staff reports. The licensing division, Mr. Leonard Rivas, excuse me, licensing manager, would you mind please giving us that report?
Yes, sir. Good morning, advisory board members. Thank you for being here this morning. My name is Leonard Rivas. I'm the licensing manager for the Hearing Instrument Fitters and Dispenser program. Excuse me. You have a copy of the report in front of you, and I'll go over a few numbers with you on the report. So statistics for the Hearing Instrument Fitters and Dispensers at the end of the first quarter, we issued 22 new licenses. We renewed 82. And at the end of the first quarter, the population for hearing instrument fitters was 727. For the apprentice, we issued 20 new licenses. We renewed one, and then the population at the end of the first quarter was 61. And then for temporary training permits, we issued 31 new temporary training permits. We renewed 21, and then at the end of the first quarter, the population for the temporary training permits was 187. That concludes my report. I'll be happy to answer any questions.
Having heard no questions, we'll move on to item number 2. Thank you so much for your report.
Thank you.
To the Education and Examination Division, Simone Cortez, the program specialist, please.
Good morning, everyone. My name is Simone Cortez, and I'll be presenting the report for Education and Examination Division. The first chart we have here shows our overall practical examination statistics. We can see here that our numbers are staying fairly consistent. Scrolling down, please. Here we have a continuation of that chart, breaking it down by sections. And again, our numbers are looking the same. Scrolling down, please. Here we have our continuing education statistics. Our FY 2025 was updated this morning to reflect the proper numbers. And again, we're seeing about the same numbers. And this also includes our new registrations, renewals, and also our course approvals. Scrolling down, please. And then, of course, we have our jurisprudence exam numbers for total test takers. And then we have our updates. Again, we'll be teaming with PSI and THAA to hold an additional practical exam session in Houston, Texas this June. The candidate information bulletin will be updated once the information has been finalized. That concludes my report. Do we have any questions?
Richard Davila, I have one question. Did you say in June of 2025 at the Texas Hearing Aid Association meeting that there'll be a 4th exam for the year?
Yes.
Okay. And those spaces will be filled like all the other spaces, people that are in process looking for an exam will be offered that?
Yes, we're finalizing the amount of slots and time periods that we can offer for our date in June. So we are working on
Will it be
finalizing.
multiple days or just one day?
I'm not sure yet. I can get that information from my manager and provide that to you guys.
Okay, I appreciate it.
Thank you.
Great questions. Any other questions or comments? Again, I appreciate TDLR is doing some additional looking into the potential of getting the International Hearing Society exam data for us as well. So thank you for working on that.
Yes, and we do have a contact for the advisory board should they wish to request those numbers from IHS that I will be sharing with you guys after the advisory board.
Outstanding. Thank you very much.
Of course.
All right. Any other questions, comments? All right. Then we're going to move on to the Customer Service Division. Thank you very much for that report. Ms. Maya Rodriguez, Customer Service Manager, the Customer Service Division.
Good morning, board members and TDLR staff. My name is Myra Rodriguez, and I am one of the managers that oversees this program in our division. Going over the statistics for this current fiscal year, have been pretty consistent with the trends we've seen in the previous fiscal year. We did have a little uptick in January. Usually that is the time that we went from December, 166 total contacts to 201 total contacts in January. It looks like it's about the same trend that we've seen in the previous fiscal year. We currently don't have the February data, or we didn't have it when it was available, when the report was due for us, but I'm available to any questions that you might have for me.
Just curious, what do you think the uptick in January is from?
The holidays, honestly, we see this across the board with all of our programs. January is pretty busy for the call center for us.
Interesting. Thank you. Any questions or comments? All right. Well, thank you very much for your report and for all the work you do. We'll move on to item E4, the Enforcement Division. Our prosecutor, Shauna Almask. Did I say that correctly?
It's Almashuk.
Almashuk. My apologies.
Good try though. It is a mouthful.
Well, thank you for being here this morning.
Yes, thank you all. Good morning, board members. My name is Shauna Almashuk. I'm a prosecutor for the Enforcement Division. I'll be presenting the report for you today. As you may recall from our last meeting, we have updated the Enforcement Division's report to the new format that you see on the screen, and I'll be covering key statistics and a case highlight today. At the top, you have the division's performance measures. You'll notice that between fiscal year 2024 and fiscal year 2025, the number of complaints opened has continued to decrease, which is great news. If we jump ahead to the top of the next page and take a look at the pie chart, we can see that most of the complaints come from the consumer. This is a good check and balance on the program because it's coming from the public. And then looking at the orders issued section just below, we see that we did have one default order that I will point out in our case highlight later. And at the top of the next page, you can see that we had 2 cases closed without disciplinary action. One case had insufficient evidence, and the second case was closed for another reason not listed because it's too infrequent to have its own category. In the next section, you can see the alleged violations at opening are scattered across the categories, with records violations having 2 and all others having 1 except for the last category. And then down at the bottom of the page is the case highlight mentioned earlier for your review. We are still actively seeking licensed hearing instrument fitters and dispensers that are in good standing to serve as subject matter experts to assist our enforcement division with complaint case reviews. As a reminder, subject matter experts review complaint cases, generally involving standard of care issues, during the investigation stage of the enforcement process. If any licensed hearing instrument fitter and dispenser is interested in becoming a subject matter expert, please have them complete the expert witness application on TDLR's website. Once the application is submitted, we'll send a questionnaire to each applicant to complete and return, and documents are screened and then contracts are issued to approved subject matter experts. I'm available to answer any questions that you might have.
I was just curious, how are people notified that you need that assistance?
For
Like
the experts?
Dispensers and fitters, yes, ma'am.
So we can send out mass email to hearing fitter dispensers, and also by making announcements here at the advisory board. The advisory board members can also mention it whenever they're at other programs or events for hearing instrument fitters.
Very good, thank you.
Shauna, Richard Davila, what did you say is expert witness form? Is that the form what's that what it's called?
Yes, I think it's called the expert witness or expert. Let me see. Let me get the correct language. It is called expert witness application.
Okay, thank you.
Yes.
Very good. Very good, very good. Thank you. Any other comments or questions from anyone? All right. Thank you again for your
Thank you.
report. Thank you for that. And we will move on to item 5A. Ms. Erica Rodriguez is going to give us a report on the compliance division.
Hi, good morning, board members. My name is Erica Rodriguez. I am our compliance division, and I'll be providing the staff report for today. So I'll begin with the current projects that we have. Our staff does continue to assist stakeholders and other divisions within TDLR with questions that may arise or projects within other divisions where assistance is needed. We are always here to assist anyone with any questions or projects that anyone may have. We also have been really busy with the 89th legislative session that began in January. We have several of our compliance staff members who have been assigned to bill analysis teams. So that's keeping us really busy. And then also, we did assist our licensing and E&E division with the new continuing education audit process. It's just a reminder that audits are going to take place after the renewal moving forward. And then also in our outreach, we just recently published our TDLR Health Monitor newsletter that was published February 21st. We do send out an email notification with that Health Monitor newsletter, but if you're not signed up for those emails, then it can be found on our TDLR main webpage. Also, our staff is excited to be at the Texas Hearing Aid Association conference this summer. We will have a booth and we'll be there to answer any questions that anyone may have, or if you want to stop by to say hi, we will be there. So we're excited for that. Also, if you do have any other outreach that you would like us to attend, please send an email to me or to our compliance division, and we'll be there to assist with that. That does conclude my report. If anyone has any questions, I'm available to answer.
Erica, Richard Davila, I
Yes, sir.
wanted to ask about the new continuing education audit process. Do I understand that people will receive a license renewal, they get their license renewed for the next 2 years, and then subsequently, the next week, the next month, be asked to provide their continuing education for the previous 2 years? Is there some kind of time limit? Normally, the end of the month, you wouldn't be able to renew your licenses. You would be able to renew it, and then there'll be a timeline afterwards to provide that information.
So currently, what will happen is you'll pay your renewal fee and we'll renew the license. And then at a later time, we'll audit and ask for your continuing education certificates. I'm not sure as far as the date that they'll go back to ask, probably just within the 2-year period, but I don't know the exact date.
Okay, and then you'll be asked to provide the continuing education that was required to renew your license. Should you not be able to provide that, there'll be a process normally the process is just non-renewal, but since people will be in a 2-year license renewal, if they can't provide the continuing education in arrears.
Their continuing education certificate at that time, if they're not able to provide that.
The 20 hours for the previous 2 years, this new process will allow people to renew their license, and then being asked in arrears, if they can't produce that continuing education, I would think there would be need to consider some type of timeline for whether you ask for it 6 months after renewal or 6 weeks. If you give somebody a year to get it back to you, and they can't provide it, in the old system, they just wouldn't get a renewed license. And in this system, it seems like they'd be licensed the whole time.
So I can get a little bit more information and then get back to you in regards to that. I know that their license is going to be renewed and then we'll audit them at a later process. I don't know how far back they're going to go as far as auditing, but I can get some more information and then send that out to you.
Okay, I know they'll go back the 2-year period to renew your license. I can't imagine them going back 4 years,
I
but
don't think they would go back
yeah,
further
just,
than the 2 years.
yeah,
It's
just the
going to
2
be within
years.
the renewal period, but it's
Okay.
just important for everyone to save their continuing education certificates for sure.
Okay.
Yes, sir. Was there any other questions?
It's a great question with with change. You always want to know how it works, certainly. And we appreciate you guys being at THAA. I know when I'm there and somebody comes up and says, hey, I like to introduce people to you guys because it certainly is nice to put a name with a face and have you guys present so that people felt like they can reach out to you if they have a question.
Thank
So
you.
All right. Well, thank you very much for that report. Let's move on to item 6, the executive office. I believe we have Deputy Executive Director Susanna Holt Cutron. Hopefully I didn't butcher that too badly.
Good morning, Chair Brooks. You got it just right. I am Susanna Catrone. I'm the Deputy Executive Director over Regulatory Services. That includes field inspections, compliance, as well as enforcement. I'm happy to join you here today. I started with the agency in October, just before your last advisory board meeting. There is one piece of legislation that I wanted to draw your attention to, and we will be happy to provide you a copy of Senate Bill 904 following the meeting. As I understand, it's not currently in your materials, but it is a cleanup bill for chapters 401 and 402 to align these statutes with agency practices with regard to our programs, and also to ensure compliance and mirroring of federal law. Sections 1 and 2 modify both chapters 401 and 402 to remove the reference to the advisory board's requirement to convene in a meeting before we initiate rulemaking. We recommend removing this language to allow rulemaking to proceed as it does with any other program. Our general practice, and the one that we will continue with your board, as well as the speech language pathologists, is to take any proposed rules to your advisory board. This will simply streamline the rulemaking process and allow it to occur as it does for any other program the agency administers, and avoids having to schedule those meetings and convene the boards to initiate rulemaking. I'll continue unless there are any questions with regard to that first change.
Was that Senate Bill 905?
904.
904.
Yes, sir. Section 3 amends Section 402.305. And Mr. Davila, this kind of goes back to the questions that you had regarding continuing education. This provision would remove the continuing education exemption for those licensed less than 24 months. And this aligns again with TDLR's other programs, including many health professions that do not provide an exemption from continuing education during the early years of licensure. The agency does not see a compelling reason to treat new license holders in this industry any differently, and encourages practitioners to be up to date on the newest techniques and research, and therefore recommends repealing this particular exemption.
Could you repeat that for me? The repealing, who's exempt from continuing education right now?
Currently, under statute, those who have been newly licensed within the first 24 months are exempt from the continuing education requirements. So this would remove that reference.
And this is Lance Brooks. I had followed this bill a little bit, and somebody with more history than me, I didn't understand why that provision was there. it really makes sense to me to remove that because it seems contradictory to the other rules that I've seen.
I recall the rule was that temporary training permit holders or apprentice permit holders, as soon as you got your license, you had to have continuing education in specific areas. And I wasn't aware that people fully licensed, less than 24 months, didn't have to provide continuing education. So I'm in favor of that as well.
Yeah, Dusty Potter. I know at one point during the apprenticeship year, yeah, you had to have 20 hours of continuing education, and they had to be classroom, and they were in specific subject matter sections, like Richard said. I would wager the reason why that exemption for the first 2 years after renewal was basically in effect because during that apprenticeship year, you were getting 2 years worth of continuing education, and it all had to be classroom. So it seems like that next, like first renewal period, avoiding it might be rational, but I don't think that's the current setup anymore. So I think probably that was just a rule that we just didn't eliminate as we changed the process in the past. That would be my guess.
Yes,
So-
sir. This is considered a cleanup bill in order to align statute with practice.
I have a question. So are you saying that once a person is licensed, how long after that do they have to get their continuing education? Is it after 2 years or a year after, or when do they have to have continuing ed?
It would be within that 2-year period before applying for the renewal.
I want to say with other licenses, because you have to have so much education and, as you're saying, classroom hours or whatever, I thought that was kind of a standard for new licensees, but maybe I'm mistaken.
When we circulate the legislation, it will include the markup. So you will see existing statute struck through and any amendments underlined. So you'll be able to see exactly what is changing or being recommended for change. And then if you're ready to move on, I'll hit the final section that involves another slight amendment. Section 4 of the pending legislation amends Section 402.402A of the statute, addressing the sale of an instrument to a minor. This change will align state statute with federal regulation and requires the physician who authorizes the sale of device no longer to only specialize in diseases of the ear. It expands it so that any physician can authorize the sale of a device to a minor. And while it is preferable that a doctor who specializes in diseases of the ear provide the authorization, now this will allow those in more rural areas to avoid having to see a specialist, and we see it as an efficiency benefiting consumers and allowing this to expand the current population of doctors who can authorize that sale. If there are no other questions, I thank you for your time this morning.
Thank you. Appreciate your update. Any other questions or comments from anybody?
Yeah, I think I have a question. With the sale of all of the over-the-counter hearing aids, does that affect any of the services or oversight that the agency provides? I mean, I understand it's unlicensed people, but there's lots of over-the-counter devices being sold. So does that impact any of the services?
I hear your concern, but no, it would not impact our compliance efforts or our enforcement efforts.
So I guess my question is, if a physician says, okay, we want this person to have a device, and let's just say they go to an unlicensed person, is there any liabilities or oversight by anyone?
Certainly, the licensure requirements are still firmly in place for your industry, and that would be a violation.
If I were to answer your question, I think if it's defined as a over the counter, then there's very little. It's defined specifically as over the counter, and there's basically no rules governing that. I think if it's defined as a clinical device or a hearing aid, then the rules apply, is my understanding of the way the federal regulations rolled out and the way it's applied in the Texas rules as well. Would y'all
Yes,
not
and
agree?
this is Richard Davila, and that particular provision is specific to minors, people under the age of 18, expanding this that all doctors can make this recommendation. But it was specific to people under the age of 18. Is that correct?
Mhm.
That is correct. It is specific to a hearing instrument being sold to a person 18 years of age or younger.
And I guess my question was more general, simply because the devices that are being sold, people are calling them hearing aids. I'm just looking at the consumer protection side. I mean, I know the agency protects and has a lot of oversight over licensed people, but is there anyone protects the consumer on this? Just curious.
Dusty Potter. So in regard to this provision, over-the-counter hearing aids are technically and through FDA regulations not supposed to be sold to minors, under 18 anyway. Of course, there's nothing stopping a parent from doing that. I mean, that's the reality of the situation. But however, a hearing instrument that's sold in that way isn't sold and dispensed by a licensee, so the person doing it is not going to be subject to the TDLR licensing act that governs our licenses. The guy at the counter at Best Buy doesn't carry a fitting and dispensing license, and the fitting and dispensing license is, in essence, there for the fitting of prescription hearing devices, which are a separate category than over-the-counter hearing devices as defined by the FDA.
Okay, thank you.
Caveat emptor, I believe, is the phrase, unfortunately.
Thank you all. We'll circulate that legislation.
Thank you. Thank you very much. Great discussion today, everyone. Appreciate it so much. Again, appreciate everybody being here. Want to move on to item number F, discussion and possible recommendation on the proposed amendments to existing rules at 16 Texas Administrative Code, Chapter 112, et cetera, et cetera, et cetera. Would love to call on Assistant General Counsel Chris Funderburg and ask him to present these materials, please.
Thank you, Presiding Officer Brooks, board members. Is everyone, I don't have the rules displayed, instead I have the public comment that we've received. Is everyone seeing that on their screen?
Yes.
Oh, great. Okay. So again, I'm Christopher Funderburg, Assistant General Counsel. Before the board today are the proposed amendments to the Hearing Instrument Fitters and Dispensers Program Rules located in Title 16 of Texas Administrative Code, Chapter 112. In brief, the proposed amendments affect continuing education requirements for hearing instrument fitter and dispenser apprentices, license holders, and CE providers. The proposed rules allow more flexibility on the methods of CE delivery and the types of CE hours that may be obtained, and they eliminate the need for individual CE courses to be obtained by the department. Except for one modification, which is subsection 112.7G, which I'll go into in a moment. The rule amendments presented today are identical to the rule package presented to this board at our last meeting on October 30th, 2024. That rule package, including the requested change to 112.72G, was filed with the Texas Register on November 15th, 2024, and published for comment by the public for comment by the public on November 29th, 2024. The comment period closed on December 30th, 2024, and the department received one comment from the public, which I'll go into now. So the comment was submitted by the organization the Texas Hearing Aid Association. TAHA's comment did not, and I'll scroll down to the beginning of their comment. THAA's comment did not directly address the content of the hearing instrument fitters and dispensers rule package, but was a proposal by THAA to assist TDLR with CE course provider approval. Specifically, THAA TAAA offered to serve as the approved CE provider and oversight body for hearing instrument fitters and dispensers in the state of Texas. The merits of TDAA's offer are outside of the scope of the proposed rules before this board today, so it is not something we can address. That said, I believe that Presiding Officer Brooks, you wanted to discuss this some with the board?
Well, I saw it in the packet and you've answered my initial question was, since it was in the packet, I didn't know if the board needed to do something in regard to their proposal. And I guess the second part of that is, as it's a proposal, not a review of the existing. So what are the next steps that TDLR would take in response, or should this board take in response to this request by THA?
Richard Davila, if there's a discussion about THAA being the gatekeeper, if you will, for continuing education, I think there's, if that's even being considered by TDLR, I think there's some conflict of interest. THA is a big provider of continuing education, and if other continuing education providers have to go through THA for approval, that's you run the risk of having courses not approved, or Texas is a big state, and I know THA gets together once a year, but having everybody go to Houston is a long haul. And
I apologize, Mr. Davila.
Yeah.
I think you're raising valid points. Unfortunately, since the discussion that you're having is relevant, but not on the agenda. Since what we're talking about is potentially affecting the entirety of the license class, we can certainly have this discussion, but we should add it to an agenda item for our next meeting. If that makes sense?
For sure.
I'll go ahead and make a note of that, and then we'll when we come back around at the end of the meeting, we'll be sure to add that for a later discussion. But yeah, no, unfortunately, due to the Open Meeting Act's requirements, are the scope of what we can discuss is fairly limited. But it is, as you pointed out, a relevant concern. So we'll go ahead and make sure to discuss that at a later opportunity.
Okay.
So that I think we're with the discussion that we've had, I think I'm going to go ahead and close this comment, and I'm going to share the rule package that's going to be presented to the board for approval today. Excuse me. Are you all seeing a document that starts chapter 112, hearing instruments, fitters, and dispensers?
Yes.
Great. So as I was saying, the rule package before you today is unchanged from when you last saw it, except for one change to 112.70G. I'm sorry, I think I may have misspoken earlier. One moment. I'm going to have to scroll down a little bit. I think I just said 70. It's actually 72G. At the prior meeting, excuse me.
There is no 7.2.
Oh yeah, I'm sorry. I must have misspoken here. Let me go ahead and. Here we are. I apologize. 112.70G. As I mentioned, the rule package before you today is unchanged from when you last saw it, except for one change to 112.70G, which governs the number of CE hours that can be claimed by a licensee serving as a proctor during a practical examination. Specifically, the proposed amendments authorize license holders to earn continuing education hours by serving as proctors for practical tests, with a maximum of 1 hour per test date and 4 hours per license term. There has been one change to the subsection G. At the last advisory board meeting, this board requested that an additional limitation to the accumulation of continuing education hours earned by serving as a proctor for the practical test. As amended, subsection G clarifies that all continuing education hours earned by proctoring are limited to in-person hours. This amendment better reflects the in-person character of serving as a proctor. Now, I'm happy to go over any other aspect of this rule presentation with this board, as well as discuss any other suggestions or changes that you might have. But if you're satisfied with the current version, at this point, I'd like to ask for a motion and a second to recommend to the commission to approve the proposed rules as presented. That said, this is not if there's other aspects of this rule package that you do want to discuss, now is a perfect time to do so.
Richard Davila, I would make a motion to accept the rules with the one change to 112.70G as written.
Dusty Potter, I would second.
All right. All those in favor? Or do we need to do the roll call vote?
Yeah, let me do a roll call vote if you don't mind, please.
Okay.
Mr. Brooks, okay. Christopher Beisel,
I approve.
Richard Davila,
In favor.
Amy Trost,
In favor.
Dusty Potter,
In favor.
Deidre Stewart,
In favor.
and presiding officer Lance Brooks.
In favor.
Motion passes.
Thank you.
Thank you very much. So we're going to move on to item number G, discussion and adoption of the enforcement plan. We're going to call on Chief Prosecutor John Medlock for a discussion of that, please.
Good morning, board members. Again, my name is John Medlock, Chief Prosecutor here with the Texas Department of Licensing and Regulation. I'm bringing for you today basically kind of an update to the penalty matrix for the hearing and fitter dispenser program. This matrix was first implemented in 2017. And it has not been amended since then, so it's a good time to kind of look at this and add some updates. Just as some reminders about what the penalty matrix is, it's kind of a guide for the prosecutors, such as Shauna, to use when potential cases come before us for disciplinary action. It also is something that is published, and it puts the industry on notice to understand what it is that potential violations could be in the event that any complaints are filed against them. And like I said, it's guidance for our prosecutors of trying to determine what kind of penalty to ask for and to ensure that we have kind of some clarity and some consistency across the program when trying to prosecute similar violations. What it doesn't do is it doesn't create law. Essentially what we do is we just lift the violations from the statutes and the rules and place them in this one document. It also does not obligate the department to impose a penalty for a said violation, only if we only use it in the event that we do need to go after a violation. Furthermore, it's not kind of binding on our commission. Ultimately, if there's a final decision that goes through a hearing process that needs to be made. And Helga, if you want to bring that up real quick, we'll kind of just go over some of the different ranges there for everyone.
Up. I apologize. Give me 1 second. I will.
Just to kind of preview as she's bringing that up, the good thing is most of the changes that were made were non-substantive, or what we would call non-substantive. Much of it was cleanup. Again, you can imagine after being in effect for 8 years, some of the rule citations have changed a little bit over the course of those 8 years. So that's what the vast majority of the amendments to this are. There are a couple of additions that I did want to point out when that gets brought up to your attention. But again, what we do is we do break these into different classifications, Class A through Class D, with Class A being kind of the least severe. We do have subject headings to kind of group like violations together. You'll see here in a minute under Class A.
Time for some reason.
No worries.
There we go.
There we go. Okay, perfect. As you can see here, you got Class A, you've got up to a penalty range. Again, it doesn't bind the attorney on the meaning that if a case comes around with a Class A violation that we have to go in this range. It just is kind of our guide if we do need to. At the same time, I think it's actually on page 7. It's kind of what I really wanted to point their attention to. We've been talking a lot about CE classes and new kind of requirements within the CE realm. That's the vast majority of the substantial changes that have happened to this penalty matrix was in right there. Go one up a little bit. Sorry. Keep going right there. So you'll see a whole new section for continuing education violations, just to reflect this kind of new reality of being able to renew without having to provide that CE up front and having the audit process on the back end. So that is kind of what this new kind of group of violations are. They do fall within the Class C range, which is $1,000 up to $5,000 penalty and or revocation. Just in terms of kind of what we did is we made these amendments or these changes and modifications. We sent it out to a couple of the members of the work group, the enforcement work group, Mr. Brooks and Mr. Davila, for feedback. We did get some feedback in terms of the amendments. Mr. Davila, I just kind of want to address a couple of your concerns about creating some tiered warning systems. The great thing about this is like I was stating, is just because we have this, it puts the public on notice, but it doesn't bind the prosecutor, because we do understand that cases all are unique and they take on different backgrounds. One of the things that is built into this enforcement plan, which this penalty matrix is part of, is there are factors which we consider with every case, including the severity of the violation, whether it was willful or intentional, did the respondent act in good faith to mitigate the violation? Is it kind of a habitual or recidivist nature, meaning is this person continuously flouting the law? The level of sanction and penalty necessary to deter future violations, and then kind of any other matters that justice might require. So those are factors that we consider in every case. So to your point about creating some kind of warning systems, that's something that's already kind of baked in and built into the process. We used to have a tiered system in the sense of first, second, and third violations. What we found is when we did take those cases to the State Office of Administrative Hearings, the judges would often confuse that when, if we did have a person that had a subsequent violation, they would kind of look at it as a situation. It's like, well, it wasn't a subsequent violation for that violation. It's just that they violated two different laws and you can't go first and second. So it was a little bit confusing for the administrative law judges. So that's kind of why we've gone to the single range of penalties with it. Well, the single kind of penalty with ranges versus kind of the tiered system. Also, a comment that you had about focusing on consumer safety. One of our priorities that we've built kind of into this system is specifically that is the Class A through D system, with C's and D being the more severe penalties. Those are the ones that do focus mainly on the consumer safety kind of aspect of things. We've also been required through some legislation, the sunset process a few years ago, to create a priority system. I believe Shauna has spoken with that in prior meetings about how we've created that, where we do kind of prioritize our cases based on health and safety kind of consideration. So a lot of the comments are fantastic and love looking at them. We've just kind of already have baked them into this process a little bit. So if you guys don't have any questions, if you do have any questions, feel free to ask those away. But ultimately, I will be asking for a recommendation for you guys to vote to send this to the commission so that ultimately we can have them adopt this and our prosecutors such as Shauna using this in the future.
Richard Davila, I'd make a motion to send this draft matrix to the commission for adoption.
Thank you. Is there a second?
Dusty Potter, I'll second.
Thank you very much. Angelica, do we want to do a roll call vote, please?
Yes, please. Okay. Christopher Beisel,
In favor.
Richard Davila,
In favor?
Amy Trost,
In favor.
Dusty Potter,
In favor?
Deidre Stewart,
In favor.
and Presiding Officer Lance Brooks.
In favor.
Motion passes. Thank you.
All right. I appreciate it, everyone. Thank y'all.
Thank you very much. It is a bit daunting when you read that list of penalties. It certainly is nice to think that there would be attempts to work with people before they, some of these could be, depending on the number of violations, could be pretty significant. So let's move on to item number H. Recommendations for agenda items for next board meeting. Are there any items that people would like to bring up for the next board meeting?
As always, if you think of any outside this meeting, feel free to call me or email me, and I will keep track of those for our next meeting.
I know one that is on my mind is the ethics requirement that is in some of the licensures. In my reading, I don't see it specifically addressed for the dispensers. So I want to certainly do some research on that. My wife's an audiologist. I have and a speech pathologist. My daughter's a speech path, and they're asking me, does the dispensers have to have an ethics course? And as I read the rules, I don't see it, but I may have missed something. So I think that would
You
be.
didn't, we don't have a ethics requirement.
I couldn't find it anywhere. So I thought it would be. I was struck by the THA proposal. And again, my question was, what do we need to do with that? But they were talking about the ethics requirement in that proposal. And I thought, well, that's an interesting thought if we don't have a rule related to it. So I think it'd be beneficial, if nothing else, just to explore whether there's some requirement out there that I'm not aware of, or as Mr. Davila just mentioned, he's not aware of it either. I just don't like gotchas.
So presently, the continuing education doesn't require that you have so many hours of ethics?
It does not.
Neither does the bar to licensure or any of the contact training hours or anything in that regard. So that I don't think that would be a bad thing to add somewhere in the chain there. It might be good to discuss for sure.
I agree.
Well, again, yeah. So good. Could at least take a look at that. Looks like you had a comment there, sir.
Chairman. Thank you, Chairman, board members. Chris Funderburg with General Counsel's office. This may also be something that you'd want to. This discussion may be something that you want to sign out to a work group comprised of board members, perhaps a licensing work group or a continuing education work group, if you want to take the discussion to a smaller piece of the board, or if you'd rather have the entire board discuss this at an open meeting, we can certainly do that as well. The agenda item would probably be the full board, and but assigning it to a work group would be something that we could do offline.
Okay, well, let's do that then. Let's do that. Thank you.
Thank you.
Just think it'd be worthy of taking a look at.
I agree. Thank you.
Thank you. One more question that I had was that the THAA proposal. I think Mr. Davila had many significant and important concerns. I was thinking that we should at least someone should at least review that. Maybe the subcommittee would perhaps review their proposal to give them some sort of response. That would seem like a reasonable thing to do. Any thoughts on that?
Yeah, are you thinking well, I guess that would be the education subcommittee. So that's me and Amy, right?
That would, to me, be a wise thing to do, even if it's thank you for your proposal. No, or thank you, whatever y'all's recommendation would be, but it seems like it would be good for someone to at least give them the courtesy of a response or a recommendation to the board. Any discussion on that, or?
So yeah, structurally, do we need to add this as an agenda item to the next meeting so that we can assign it to the subcommittee? I think that's structurally how we have to do that, right?
Excuse me, Chris Funderburg, General Counsel. Yeah, I'm afraid so. It's the two-step. Yeah.
And Mr.
Yeah.
Brooks, I'm sorry, can you repeat what exactly it is that you wanted to add to the agenda for the next meeting? The second, I got the ethics requirement, but I didn't get the second one. I'm sorry, I was making notes.
Well, I think you said my name. The THA-CE proposal.
Okay.
Was a comment. I was just thinking that it would be, maybe the word would be respectful or do due diligence on their proposal to give them some sort of feedback back to them. Yes, sir. Looks like you got your hand raised there, sir.
Yeah, I was provided some correction, additional that we can actually assign the work groups outside of the meeting, so we don't have to create an agenda item in order to do so. We can just bypass that and then have the board members who are assigned to the work groups consider that without creating agenda item and then doing it at the next meeting.
Richard
Okay.
Davila, Lance, I'd love to be on if you're going to assign a work group, just to have a dissenting communication, in the work group, because, I do see some, I'd like to participate, in that discussion before if you're going to do it outside of the board.
I guess that's what my concern would be, because I think that everyone might not be on the same page. So I think in order for a work group to address it, it would still be good to have the opinion of the various participants.
Certainly. And I think the idea would be for the work group to do the groundwork, ask the questions.
Yeah, talk to stakeholders.
Talk to stakeholders,
Yeah, I mean,
and then bring that back to the board for
I
discussion.
also feel like we could just add the discussion to the agenda for the next meeting for us. I mean, I don't have a problem with it being a larger discussion. And to me, Amy and I are two of the members that are in here. If we're to take this down to the education subcommittee and then bring it back up to the board for full discussion, I don't see why we don't just add it as an agenda item next meeting. But that's my take.
Would that be acceptable to everybody? Or
I
again,
think
there's lots of rules out there trying to.
Yeah, as long as that meets the rules. But I certainly see where Richard's coming from, and I think
Sure.
I think this needs to be discussed because I mean, just my opinion is this is a little bit contrary to the intent of the change that we made as far as the CE providers versus courses anyway. So, but can we discuss next time?
Okay, so just verify we want to add this as an agenda item for the full board to discuss, and then if need be, assign it to a work group. Is that good?
That would be my recommendation.
It can be similar to what we did with the rules, where the rule work group went over the details of the rules with the general counsel and our divisions, and then presented the results of their review to the board. And so, yeah, no, so I would recommend adding an agenda item, and then we can work with assigning members to the work groups outside of the meeting.
Which would still allow the full board to weigh in and have concerns or discuss further, but would let a little bit of the groundwork to be done in advance.
Could the work group not be scheduled when we're going to be together in June with some of the TDLR going to be at the convention along with us members on the board? Or do we have to wait till we have?
Yeah, not outside of open meeting.
Yeah, there's work groups, as there's less than a quorum and no official action can be taken, don't need to be, basically the meetings can be set around everybody's schedule.
Okay, so let's put an agenda item. Let's do the research, and if that sounds okay, and we'll move forward. Any other agenda items? Very good. And all right, Ms. Lopez Sparks. And it's interesting, I hope I did that correctly as well. I hate to say someone's name incorrectly. I noticed on your screen, it actually says Sparks Lopez. And so I certainly don't mean to offend if I'm saying that in the wrong order there.
Oh, No, it's Lopez Sparks. On my side,
Great.
it shows Lopez Sparks, but yes,
Great.
you're good.
Great, great. I think you were going to poll the board for time and date for a future meeting.
Yes, sir.
Thank you, thank you. Any other discussion items? Any other concerns that we missed there? And again, great discussion today. I thought it was, I mean, I'm always pleased to see the board engaged and appreciate the board being here, and certainly do appreciate everyone taking the time to bring thoughtful comments and discussion. So thank you for all that. Having said that, it is 10:59 and the meeting is adjourned. We'll go from there. Thank you so much.